India's relationship with the environment is deeply rooted in its ancient traditions. Hinduism, Buddhism, and Jainism emphasize the interconnectedness of all living beings. This reverence for nature fostered a sense of environmental responsibility, evident in practices like the protection of sacred groves and water bodies. The arrival of colonialism disrupted this delicate balance. The British Raj prioritized resource extraction to fuel industrial growth, often at the expense of the environment. Forests were cleared for timber and agriculture, leading to deforestation and habitat loss. The exploitation of natural resources continued unchecked, laying the groundwork for future environmental challenges. This period witnessed the enactment of some environmental laws, but their primary focus was resource management, not ecological preservation. The Indian Forest Act of 1878, for instance, aimed to regulate forest use, but it also facilitated the commercial exploitation of timber. Similarly, laws governing water resources were primarily concerned with irrigation and revenue generation, neglecting the ecological needs of rivers and other water bodies. The colonial legacy left India with a dual challenge: balancing economic development with environmental protection and addressing the ecological degradation caused by exploitative practices. India's independence in 1947 marked a turning point in its environmental journey. The Constitution of India, adopted in 1950, enshrined the principles of environmental protection. Article 48A, a directive principle of state policy, mandates that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Although directive principles are not legally enforceable, they serve as guidelines for policymakers and reflect the nation's commitment to environmental well-being. Furthermore, Article 51A(g), a fundamental duty of every citizen, emphasizes the responsibility to protect and improve the natural environment, including forests, lakes, rivers, and wildlife, and to have compassion for living creatures. These constitutional provisions provided a strong foundation for the development of environmental laws and policies in post-independence India. They reflected a growing awareness of the need to balance economic development with ecological sustainability. The 1972 United Nations Conference on the Human Environment, held in Stockholm, Sweden, was a watershed moment in global environmentalism. India, as a participating nation, played an active role in shaping the conference's declaration, which recognized the fundamental right to a healthy environment. The Stockholm Declaration served as a catalyst for India to strengthen its environmental laws and policies. It highlighted the need for international cooperation to address transboundary environmental issues. Following the Stockholm Conference, India established the National Committee on Environmental Planning and Coordination in 1972, later renamed the Ministry of Environment and Forests. The ministry became the nodal agency for environmental protection, responsible for formulating and implementing environmental policies and laws. The Stockholm Declaration's influence extended beyond institutional changes, inspiring the enactment of specific environmental legislation in India. The Water, Prevention and Control of Pollution Act of 1974 and the Air, Prevention and Control of Pollution Act of 1981 were directly influenced by the principles enshrined in the Stockholm Declaration. The 1970s witnessed the enactment of several key environmental laws in India, marking a significant step towards a more comprehensive legal framework. The Water, Prevention and Control of Pollution Act of 1974 aimed to prevent and control water pollution and maintain the wholesomeness of water resources. It established pollution control boards at the central and state levels to monitor and regulate industrial effluents and sewage discharge. The Act empowered these boards to set standards for water quality and take action against polluters. The Air, Prevention and Control of Pollution Act of 1981 followed a similar model, focusing on air pollution control. It aimed to regulate emissions from industries and vehicles, setting ambient air quality standards, and empowering authorities to monitor and enforce compliance. These two acts, along with the Environment Protection Act of 1986, formed a trilogy of environmental legislation in India. The Environment Protection Act provided an overarching framework for environmental protection, encompassing all forms of pollution and environmental degradation. It empowered the central government to formulate broad environmental policies and regulations. Section 5. Bhopal, a tragedy that awakened a nation. The Bhopal gas tragedy, one of the world's worst industrial disasters, struck India in 1984. A leak of toxic methyl isocyanate gas from a Union Carbide pesticide plant in Bhopal, Madhya Pradesh, killed thousands and left hundreds of thousands with long-term health problems. The disaster exposed the inadequacies in India's environmental laws and enforcement mechanisms. It highlighted the need for stricter industrial safety regulations, liability provisions, and emergency response systems. The Bhopal disaster served as a wake-up call for India, prompting significant changes in environmental legislation and enforcement. The Environment Protection Act of 1986, enacted 2 years after the tragedy, was a direct response to the disaster. It strengthened the government's powers to regulate hazardous industries, conduct environmental impact assessments, and prosecute polluters. The Bhopal disaster also led to the establishment of the Ministry of Environment and Forests as a separate entity, elevating the importance of environmental protection within the government. Section 6. The Judiciary's Green Mantle, Landmark Cases and Judicial Activism. The Indian judiciary, particularly the Supreme Court, has played a pivotal role in shaping environmental jurisprudence and enforcing environmental laws. In a landmark case, MC Mehta versus Union of India from 1986, also known as the oleum gas leak case, the Supreme Court introduced the concept of absolute liability for industries engaged in hazardous activities. This principle holds industries strictly liable for any environmental damage caused by their operations, regardless of fault. The Supreme Court has consistently upheld the right to a healthy environment as an integral part of the right to life under Article 21 of the Constitution. In cases like Subhash Kumar versus State of Bihar in 1991 and Vellore Citizens Welfare Forum versus Union of India in 1996, the court emphasized the precautionary principle and the polluter pays principle. The precautionary principle mandates that when there is a threat of serious or irreversible environmental damage, lack of full scientific certainty should not be used as a reason for postponing cost-effective measures to prevent environmental degradation. The polluter pays principle dictates that the polluter should bear the costs of pollution prevention and control measures. These principles have become cornerstones of India's environmental jurisprudence. Section 7. The Green Tribunal, a dedicated forum for environmental justice. To provide speedy and effective resolution of environmental disputes, India established the National Green Tribunal, or NGT, in 2010. The NGT is a specialized body equipped to handle cases related to environmental protection, conservation of forests and other natural resources, and the enforcement of any legal right relating to the environment. It has jurisdiction over all civil cases, where a substantial question relating to the environment is involved. The NGT follows a judicial process, with the power to summon witnesses, order investigations, and impose penalties. It has played a crucial role in addressing environmental violations, particularly in cases related to pollution, illegal construction, and deforestation. The NGT's establishment reflects India's commitment to strengthening environmental governance and ensuring access to justice for environmental issues. Section 8. Navigating Controversy, EIA 2020, and Forest Law Amendments. India's environmental laws have not been without their share of controversies. The Environmental Impact Assessment, or EIA notification, a key regulation under the Environment Protection Act, has been amended several times, often sparking debates about its effectiveness and potential to dilute environmental safeguards. The 2020 amendment to the EIA notification faced significant criticism for allegedly weakening environmental impact assessment procedures and granting exemptions to certain industries. Similarly, amendments to forest laws have also generated controversy. The Forest Conservation Act of 1980, enacted to protect forests and regulate deforestation, has been amended several times, with critics arguing that some amendments have weakened forest conservation efforts and favored industrial interests over the rights of forest-dwelling communities. These controversies highlight the ongoing debate in India between economic development and environmental protection. Section 9. Towards a Sustainable Future, Challenges and Opportunities. India faces significant environmental challenges, including air and water pollution, deforestation, biodiversity loss, and climate change. Addressing these challenges requires a multi-pronged approach, encompassing stricter law enforcement, technological innovations, public awareness campaigns, and the active participation of all stakeholders. India needs to strengthen its environmental institutions, enhance monitoring and enforcement mechanisms, and promote sustainable consumption and production patterns. Despite the challenges, India has made significant progress in environmental protection since independence. The country has a robust legal framework, a dedicated judiciary, and a growing environmental movement. India's commitment to the Paris Agreement on climate change and its ambitious renewable energy targets demonstrate its dedication to a sustainable future. By leveraging its rich cultural heritage of environmental stewardship, strengthening its institutions, and embracing technological innovations, India can chart a path towards a more sustainable and equitable future for its people and the planet.